Hey, welcome everybody to today's episode of the Law of Self-Defense. I am, of course, attorney Andrew Branca for the Law of Self-Defense. And today we're going to take a look at a video of a fatal shooting out of Cincinnati, Ohio, that many on the internets are characterizing as obvious self-defense, but which state prosecutors have charged as murder. And the prosecutors here are probably right on the legal merits. The reason this killing is likely unlawful rests on the element of innocence, one of the elements required for a valid claim of self-defense. The element of innocence requires that the person claiming self-defense was not the initial aggressor in the fight, obviously, and also that they did not provoke the other person into being the initial aggressor in order to have an excuse to use force against them and claim it was self-defense. And that's the problem in this shooting. So we'll take a look at the video of this event in just a moment and discuss what makes this killing likely a crime. But because I've just mentioned the 5 elements of self-defense, if you hang in to the end of the show, as you certainly should, I'll explain to you how you can get your own copy of our 5 elements of self-defense law cheat sheet. The 5 elements are the building blocks of any claim to self-defense. If you're missing any one required element, whatever your use of force was, it was not lawful self-defense. If you don't understand these 5 elements, you can't possibly understand the legal boundaries for the use of force in defense of yourself, your family, or your property. We want to give you these 5 elements for free. In our 5 elements of self-defense law cheat sheet, it lists the 5 elements, provides a brief description of each, and we don't charge a penny for it. Stay with us to the end of the show, and I'll explain how you can get your own copy of this 5 elements of self-defense law cheat sheet. So perhaps you've seen the Clint Eastwood Dirty Harry movie, Sudden Impact, in which Detective Callahan has an armed robber at gunpoint and taunts the robber to dare the robber to try to shoot him, saying, "Go ahead, make my day."
Go ahead. Make my day.
Or if you're of a certain age, you may recall the movie Shane, the Western, in which the professional gunslinger played by Jack Palance goads a local farmer into going for his gun. Prove it.
You're a low-down lying Yankee. Prove it. No authority.
At which point, of course, Palance quickly shoots the farmer dead. Or in real life, you may recall from a few years ago, the gunfight over the mattress left at a dumpster, in which one of the men who would be convicted of murder, sentenced to prison, goads the victim to take your swing. Take your swing. I doubt it. Take your swing.
Gunning down a neighbor after a fight broke out over a mattress in a dumpster.
You have a gun in front of my kids. What a mattress.
If you come within 3 foot of a man, they'll kill you.
Okay. You're not going to shoot my husband. Oh. Shoot me. You're dead. Point it. Point it.
These kind of scenarios go by a variety of terms, such as provocation with intent, but they all have one thing in common. None of them are lawful self-defense. The reason they're not lawful self-defense is that they've lost one of the required elements of self-defense, the element of innocence. Any claim of self-defense is made up to 5 distinct required elements. These are innocence, imminence, proportionality, avoidance, and reasonableness. Don't forget, at the end, you'll be able to grab for free your 5 elements of self-defense law cheat sheet. Now, of those 5 elements, if any one required element of self-defense is missing, whatever your use of force was, it was not lawful self-defense. By the way, in the fight to determine whether or not it was lawful self-defense, it can be very helpful to make sure you have the resources you need to prove your claim of self-defense in court to a jury. And a great way to make sure you have those resources is to be a member of CCW Safe, the sponsor of today's content. CCW Safe provides legal service membership, so many people mistakenly call self-defense insurance. In effect, they promise to pay their members legal fees if the member is involved in a use of force event, and they do much, much more. I trust CCW Safe. I'm personally a member. My wife, Emily, is personally a member. If you'd like to learn why I trust them, you can point your browser to lawofselfdefense.com/trust. I have a little video there explaining exactly why CCW Safe is the best fit for me and maybe the best fit for you as well. Also, at that URL, lawofselfdefense.com/trust, there's a discount code for 10% off your membership of CCW Safe when you choose to become a member. Again, that's lawofselfdefense.com/trust. So let's focus then on this element of innocence. The legal defense of self-defense is intended to allow a victim of unlawful violence or threat of violence to defend themselves against that unlawful violence and have their defense be legally justified and not a crime. The element of innocence holds that if you are the unlawful initial aggressor in a fight, you lose self-defense as a legal justification for your unlawful use of force. Pretty obvious, really. But there's a somewhat more subtle way to lose the element of innocence. Innocence can also be lost even if you were not the initial unlawful aggressor, but if you intentionally provoke the other person to be the initial unlawful aggressor. That intent being that you have the intent to now have an excuse to use your own force against them and claim you acted in self-defense. Go ahead, throw the first punch, throw the first punch. No one says that because they want to be punched in the face. They say that because they want things to look as if the other party were the initial physical aggressor and they were only responding in self-defense when they struck back. The legal system despises this form of provocation because it's simply someone trying to use or misuse the well-intentioned doctrine of lawful self-defense as an excuse to unnecessarily harm or kill someone. You're trying to game the system. That provocation with intent to kill is what's illustrated by Dirty Harry in Sudden Impact, and by Jack Palance and Shane, and by the Dumpster Bros in real life. If you've provoked with intent, you've lost self-defense as a legal defense, period. Now, let's take a look at the video out of Cincinnati. It's not a great video for purposes of legal analysis of a use of force event generally. The camera's pretty shaky. We can't really tell how the fight started or what the various parties might be armed with, except, of course, we know the woman charged had the gun she used to shoot dead the victim. What we can tell is there's some ongoing violent confrontation. It appears that the shooter, now the defendant, is in the driver's seat of a car and her window has been smashed out. And the shooting victim closes on her car and on the smashed window and attempts to strike her again. She claims with a knife. In fact, before we jump to the video itself, let's take a look at what the shooter has to say about this event. And I have a tweet here from X, the account Breaking 911, that has a lot of good content, by the way. So at Breaking 911, you might want to check them out. They write, shock video. Cincinnati woman charged with murder after she fatally shot rival, who she claimed attacked her and slashed her tires. The day before this defendant was arrested, she uploaded video of the shooting to Facebook. That's the video we'll look at in a moment. She wrote, quote, "This is what happened July 12th. There's 2 911 calls of me asking for them, 911, to please send somebody. I was being punched in my face, rocks thrown at me, and Naima, I guess the other party, trying to get in my car. She busted my driver's side window out to attack me. She continued to try and get in my car to stab me, and I let her hit me while I was on the phone with 911 asking for help. I told them to stop over and over and over again. I never got out of my car to fight or anything, and I allowed her to punch me more than once." Well, that sounds like a pretty reasonable narrative of self-defense at that point, especially the breach of an occupied vehicle. Under these circumstances, generally an occupied car would be treated as highly defensible property, much as if someone was breaking into your home, for example. So far, those facts seem pretty supportive of the shooter having a robust narrative of lawful self-defense. But then we have the video. And in the video, there is, unfortunately for this defendant, evidence of provocation with intent. Let's take a look at that video and see what we see. Now, there's no gore, by the way, in this video, but you will hear 4 gunshots being fired. And of course, we know that the victim of those gunshots ultimately died of the injury. So fair warning there. Okay, here we go. It's very short. It's only 17 seconds long.
You about to go to jail. You going to jail. You going to jail. You going to jail. Going to jail. Hit me again. Hit me again. Hit me again.
And there, folks, there we have the problem. Right there at the end, that hit me again, hit me again, hit me again, and then the 4 gunshots that ended the victim's life. Now, many states deal with this doctrine of provocation with intent explicitly in statute. So Utah, for example, provides in its self-defense statute, which happens to be section 76-2-402, that, quote, a person is not justified in using force in self-defense if the person initially provokes the use of force against themselves with the intent to use force as an excuse to inflict bodily harm upon the assailant. In other words, you goad that other person to attack you, that's on you. You own that fight when they attack. And then when you use force to defend yourself, you cannot justify that force as self-defense because of your provocation with intent. Now, Ohio, where this shooting occurred in Cincinnati, doesn't address provocation with intent that explicitly. It would appear, however, to cover this doctrine more implicitly in case law, appellate court decisions, and of course reflected in its jury instructions. For example, the 2024 Ohio Court of Appeals decision of State v. Bromley reminds us that, quote, self-defense requires that a defendant was not at fault in creating the situation giving rise to the affray. And they're just quoting an earlier Ohio Supreme Court decision there. Now, Ohio is somewhat remarkable in allowing a defender to be stripped of the element of innocence and therefore of the legal justification of self-defense merely because the defender shared some, quote, fault in creating the situation giving rise to the affray, close quote, because that's really what I would describe as kind of a hair trigger for losing self-defense. For example, what if you get into a simple verbal argument with someone in a parking lot? Just words, and they suddenly escalate to physical violence. And then you defend yourself against that physical violence. In most states, there would be no question that the other person was the initial unlawful physical aggressor, and that you would be the innocent victim of their attack. You'd have the element of innocence, you'd have self-defense. But if the Ohio standard is applied to find that your engagement in that mere verbal argument at first created, quote, fault in creating the situation giving rise to the affray, close quote, and it might, then you'd have no privilege to claim self-defense for your later use of defensive force against their physical attack. Even more clear, of course, would be the provocation with intent scenario. That is, where you are not the initial physical aggressor yourself, but you goad the other person to be the initial physical aggressor, so you'll have an excuse to use force against them and pretend it was self-defense. Go ahead, make my day. Or as Jack Palance said, prove it. Or the dumpster bros, take your swing. Or, as in this case, said at a point where there appears to be no imminent physical violence threatened, and said in a very calm tone of voice at that, hit me again, hit me again, hit me again. Let's listen to it here.
Going to jail. Hit me again. Hit me again. Hit me again.
Unfortunately, that hit me again, hit me again, hit me again. And when the taunt triggers the desired strike, blam, 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 with fatal results. That taunt is more than enough to give an Ohio prosecutor what they think they need to disprove the element of innocence and therefore to disprove self-defense entirely. And if this shooting wasn't self-defense, it's just an unlawful killing. Maybe not murder as charged. Frankly, I think voluntary manslaughter would be a more appropriate charge on the facts of this case, but that is a topic for another show. By the way, if you're watching this on YouTube or Rumble or any of the social media, please hit the like button, the thumbs up, smash that subscribe button until it turns red, or whatever the equivalent of those is on the social media platform you're on. That's always greatly appreciated. And as promised, I have for you how to get your 5 elements of self-defense law cheat sheet. Just point your browser to lawofselfdefense.com/elements, and you can download it right there. It's just a PDF downloaded. Provides the 5 elements of self-defense that are the building blocks of any claim of self-defense. If you don't know these, You can't possibly know the legal boundaries for the use of force in defense of yourself, your family, or your property. This cheat sheet provides you with those 5 elements and a brief description of each. It's a good, necessary starting point for any claim of self-defense. And I would also encourage you to take advantage of the opportunity to pick up a free copy of our best-selling book, The Law of Self-Defense Principles. I have that here too. Here we go. That's this book, The Law of Self-Defense Principles, written by me, foreword by Masada Ayub. I hope you know who Masada Ayub is. I wouldn't be where I am today were I not standing on the shoulders of self-defense trainer Masada Ayub, a giant in this field. Check out the book on Amazon. It's 5-star rated. It's a bestseller in its class, but don't buy it on Amazon. They'll charge you $20 or $25 for the book, plus shipping and handling. We only ask that you cover the cost of shipping the book to you. The book itself, we give you for free. Get your physical copy of the handbook to making you hard to convict if you're ever compelled to use force in defense of yourself, your family, your property at lawofselfdefense.com/free book. Or scan that QR code right there on the screen. All right, folks, with all that said, I'm going to wrap things up and just remind you that if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill. If you carry a knife, if you carry pepper spray, if you study jiu-jitsu, I do all those things. So me and my family are hard to kill. If you do any or all of those, you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until next time, I remain attorney Andrew Branca for the Law of Self-Defense. Stay safe.